Hello. I'm filming this in October of 2022, and it just happens to be Estate Planning Awareness Week. Just what we needed, right? Is another day or week to honor some other obscure thing. But as an estate planning attorney, obviously this one hits home for me. And so I decided to make this quick video answering one of the most common questions that I get. My name's Alex Meeks. I'm an attorney and the owner and founder of Acorn Law. We're a law firm dedicated to helping busy families get over their inertia and indecision to get their affairs in order. So one of the questions that I get very frequently is, what will happen to my children if I do not make guardianship designations in my estate planning documents? Now, one thing I just want to get out of the way right away is a lot of people are often worried that if they don't make guardianship designations, that their children will automatically go into stranger foster care and be adopted out. That is highly, highly unlikely to happen. And here's why. Baked into both the federal and the state law really are preferences for children who need placement to be placed with family. So what would happen if you passed away and your child was left without a parent is that the court would need to make sure that that child has a guardian who is going to care for them. And the guiding star of the court is really the best interests of the child. So if there's a fit and willing family member out there, and most of the time there is, either a family member or a close family friend, someone steps forward, chances are that person is going to be who will take care of your child. So it's very unlikely that there will be no one who steps forward and that your child will end up going into stranger foster care. Here's what also won't happen though. The judge will not be able to take the time to get to know your child and your family and all the other players well enough to make a decision as well as you can. The judge is going to do their best. They're going to take whatever evidence happens to be presented to them and make the best decision they can for your child and what they think is in your child's best interest. But the judge is a stranger. They don't know your child. They don't know all the players. They don't know the family dynamics or all the different factors. There's only so much that they can figure out. And so just think for a moment about your own family. And most people have somebody who maybe is a bit overbearing, a sibling who thinks they know better than everybody, or somebody maybe who means really well but doesn't share your values. You know, all of those people are going to be kind of on equal footing if you don't make designations. What guardianship designations do, they're not an automatic. So the judge doesn't have to honor the wishes that you memorialize. What it is, though, is a roadmap. It's a very helpful tool for the judge who's in a really difficult position to make a good decision for a young person. When you leave guardianship designations, you're leaving a roadmap. And that is such a gift, not only to your child and your loved ones, but also, quite frankly, to a judge who would rather be in a position of making a decision with the best possible information. So there you have it. That's what would happen if you died and hadn't left guardianship designations in your estate planning documents. If you're interested in hearing more about this or other legacy planning topics and you want to talk through some things, please don't hesitate to reach out to me. You can make an appointment right on my website, which is, you can see the link here. If you live in Maryland or New York, I'd be happy to help you. If you live elsewhere, I will do my best to link you with someone who can help. Love to talk to you, and I'd love to help.